Would the court like for me to give a brief factual rendition, or should I just jump into the motion?
Just jump into the motion.
Okay. So it's my belief, and I believe the law supports and public policy supports that mediation is appropriate when the parties have the information needed to evaluate their claims and effectively participate in that process. So to that end, I think the question is whether or not we're there, whether or not the parties have that information that would allow them to participate in mediation. And to that extent, I do believe we have a good understanding of the facts, both the ones we can agree on and the ones we disagree on. The claims asserted by the plaintiff, I believe I understand the defendant's defenses, and importantly, I think we have a good idea of the damages that the plaintiff has suffered in this case. This is an employment law case, so we have had that pre-suit administrative process where we exchanged insignificant amount of information between the plaintiff and the defendant. And then, of course, after the commencement of this suit, we've had document production, interrogatories, and requests for admission exchange as well. In terms of damages, it comes out to be about $120,000 in actual hard damages. Not an economic expert, but napkin math of a lawyer. And so to that extent, I'm not sure there's much more that would be needed for the parties to effectively participate in mediation. Mr. Whiting and I think we have a good relationship. I think we have a disagreement about whether or not we have engaged in meaningful negotiations. And I think that's probably a good faith dispute. A lot of those negotiations have been trying to propose resolution or mediation, and Mr. Whiting's client saying, we really don't want to engage. And so, and I think in instances like that, having a third party get involved and challenging people about the facts and the positions in the case can be quite helpful when somebody is, I don't want to, perhaps stubborn, but I don't want to characterize Mr. Whiting's client. And so if this is to continue, I'm not sure depositions would add much to either party's understanding that would be needed to effectively participate in mediation. It would add expense. It would likely cause an escalation of commitment bias on both sides because of the expense and the fees. But mediation is helpful whether or not it resolves the case. Having that conversation, spending that morning or afternoon or full day discussing and working through issues is a benefit. I think going to mediation at this point, sure, is there a risk that mediation doesn't settle a case? Absolutely, it happens all the time. But mediation does usually resolve a case. And even if it weren't in this case, it still would be beneficial to the parties. So I do believe at this time that the risk of going to mediation after written discovery, but before depositions well outweighs, or the benefits well outweigh the risk. And so therefore I'm asking the court to please order the parties to go to mediation.
Sorry, Judge, I couldn't hear what you said. You're muted at the moment.
Response?
Yes, thank you. Judge, Officer Carter was fired for a highly inappropriate, sexually deviant conversation that he initiated at work. And my client has taken the position that because of the egregious nature of his behavior, they've steadfastly taken the position in this case that they're not going to offer one dime in settlement. Mr. Lang is correct. We have a very cordial relationship, and we've certainly had a number of conversations about the possibility of some sort of resolution. And he was preceded by counsel. Mr. Carter was previously represented by a different counsel. There were a number of negotiations that were attempted by that counsel. I have attached all of those responses and attempts to the response in this case that the court has. So you'll be able to see that right from the get-go, June 7th last year, when we were first approached about mediating the case, and the response there was My client's taken the position that because of the nature of the behavior involved, they're not going to offer a single dime. There's going to be no settlement in this case. Again, in August 19th, there was actually some sort of an offer that was communicated by them. And again, the same response, not going to offer a single dime. Mr. Lang then got involved and he communicated with me in October last year and also made a pre-suit effort to try and get this case mediated and resolved. Same response. We're not interested in resolving the case. I'm authorized to accept service of the suit. Let's move forward. And so we've had a number of communications since then, Mr. Lang and I, in December and in January, and we've had a number of informal conversations in between those times. And each time I've gone to my client and I have talked to my client, and my client has taken the position that they're not interested in paying one dime. I have communicated that numerous times. And at this point, my client's position, and my client's not unsophisticated. I know the court has seen my client before, and my client has certainly engaged in mediation.
Let me ask you this. When is the mediation order? What is the date mediation is supposed to occur by, or is there a date?
But there has been no order from the court at this point. My understanding, we're on level 1, level 2. We've received no communication from the court. So my assumption is that we're working under the standard order that we've got to mediate the case.
Usually we appoint a mediator. Let me
Wow.
double check and make sure something didn't get lost in the.
Likewise, Your Honor, I have not seen anything that about mediation being ordered to happen by a certain date.
Check. It would be usually during if it's a level 2 case, then it would be during the beginning of the case. Let's see. Oh, this may be a little different. Okay, we don't even have a trial setting on this case. Okay, so Rhonda, we need to set this case for trial. Let's go ahead and set this for trial on November. All right, now let's just do January. How does January 3rd, 10th, 17th, 24th, or 31st sound?
I'm not aware of anything that I have scheduled that far out.
Mr. Whiting, do you have any objections?
I'm just looking, Judge. I think I've got trial scheduled the following week on the 9th in an older case.
You want to do
Not
the
to say
24th
that you shouldn't send me for the 3rd, but
you want to shoot for January 24th?
yeah, I mean, I've got a trial scheduled in the Northern District on the 23rd, but you know, life is what it is.
I mean, how about February 7th?
February 7th looks good, Judge.
How about for you, Mr. Lang?
Yeah, I don't have anything on my schedule that far out, Your Honor.
All right, we're going to order this on February 7th. Typically what I do is I order mediation on every case. I'm not going to, usually it needs to be conducted at least 30 days prior to trial. So what I can either just pick a mediator and order mediation with that mediator, or and then Mr. Whiting, if you want to object to the mediation, you would object. So I'm just going to treat this like any other case. Do you guys want any say in the mediation, who the mediator is, or do you want me to just appoint somebody?
I'm happy to talk to Mr. Lang. I'm sure that
Well, you need to do it right now. So
we can agree
who do you
on
want to use?
somebody.
I don't have any issue with Courtney Bass. She's pretty good.
Not going to do Courtney Bass.
Okay.
Okay. Will you make a suggestion, Mr. Whiting?
Oh, Kathy Fragnoli.
Is she still mediating?
She is.
Okay.
I've had.
I thought she moved or something. No.
No, she's back in town, Judge.
Okay, yeah, you're more up on this than I am. So, Mr. Lang, how about Ms. Fragnoli? She's very
Yeah,
experienced in this
she
area.
actually ran for a political race.
You're right. You're right. I voted. What am I thinking?
Yeah.
I voted for her. You're right.
I have no issue with Ms. Fragnoli.
All right, let's go ahead and appoint Kathy Fragnoli, Rhonda, to this case. The mediation needs to occur at least 30 days prior to trial. Is she still over with Burden, or where is she now?
Yes, she's still with Burden.
Okay. Just haven't seen her in a while. Okay, and at some point, you know, I'm not going to do an early mediation, but if you go forward with discovery and you determine, Mr. Whiting, you still don't want to go to mediation, you can object to mediation. But if you fail to, I'll just tell you, I handle every one of these cases. If you fail to attend mediation, just because you don't want to, without a permission from the court, then that's when your client gets in trouble.
And understood, Judge. I mean, at this point, you know, my client's position is fairly strident, and so, you know, the part of the objection here was to stay depositions to conduct the mediation, and of course, our intent is to go ahead and take Mr. Carter's deposition and then move for summary disposition. And so that's been the, you know, the big sort of roadblock, should we say, and the reason why we opposed this motion.
Okay.
And of course, you know, the fact is my client has taken the position that they don't want to pay a penny.
You know what, it happens sometimes. So
Mr. Whiting's been nothing but consistent in his communications. We'll grant him that.
So Rhonda, go ahead and set this for trial on February 7th. Go ahead and order to mediation 30 days prior to trial with Kathy Fragnoli. I guess the order to compel mediation right now would be denied, but I'm going to have a mediation order in place. I don't know that we really need an order. Anything else that we need to chat about today?
No, Your Honor.
I think so.
Thank you, guys. You guys have a good weekend, and we'll get those orders out soon. Okay.
Thank you, Your Honor.
Thank you, guys. Bye-bye.
Bye-bye.
I see a Mr. or sorry, it says B. Brown Shadle. I don't know who that is or what you're here for. You're muted, sir.
Good morning, Your Honor. This is Blake Brown, Shuttle Counsel for Mid-Continent and the other plaintiffs.
Okay.
On our motion to show cause.
Okay. The other side isn't here yet, but it's not 10:30. Are you with Dunn Sheehan, or is that the other side?
I'm with Dunn Sheehan.
Okay. Do you anticipate the other side's going to show up?
I don't, based on we attempted to meet and confer on February 15th, and they didn't respond.
Okay. At least when I checked this last, I didn't see. Yeah, I don't see a response either. And the other side, the attorney is Morgan.
Right, Charles Morgan.
Rhonda, can you just go ahead and call Mr. Morgan and see if he's going to join us for this hearing?
Yes.
Well, Judge, how's your Friday going?
It's good. It's
Good.
good. My kids are in town. They're leaving tomorrow. They're on spring break, and
Excellent. Where are they in school?
they're both at UT.
All right.
They're both going to I know, me too.
Yeah.
They're both going to law school next year. I think my daughter's going, or she got into UT law, and I think that's where she's probably going. And my son is probably going to Virginia. So
Excellent.
So both great schools.
Yeah. Congratulations to both of them.
Yeah, they're very, very pleased with how it's all worked out. So, anyway, how's Connor and David doing?
They are terrific. Dave's in Tahoe with his kids this week on spring break. And Connor is, plugging and going on his products cases.
Yeah, I've heard he's had some interesting cases.
He has. He certainly has. We moved offices January 3rd. We were in West Village and now we're at the Merrill Lynch building.
Okay. Where is that? The Merrill Lynch building?
Mockingbird Station, 75 in Mockingbird, right